Hello, everyone, and welcome to our webinar, Deregulation Nation, Legal Perspectives on the Changing Rules within the federal government. I'm Ron Jacobs, a partner here in the DC office of Venable. I'm joined today by my colleague, Megan Barbero, who has a great background to talk about regulation. She was the general counsel at the Securities and Exchange Commission. And before that, she was the deputy general counsel of the House of Representatives, where she got to handle a lot of really interesting separation of powers kind of issues and things like that. So hopefully today we'll be able to bring you a great conversation about the administration's efforts to sort of bring about deregulation. We had an earlier session of webinars on sort of the transition and initial outread on what the administration was up to. And so now we've thought that it would be helpful to launch this series of webinars kind of over the course of the summer to talk about the deregulatory perspective. Today, Megan and I are going to talk about sort of the executive orders that underlay the deregulatory framework and some of the legal issues that come along with that. And then we're looking forward to bringing to you a whole series of webinars that will cover the specific agencies where the different regulations will be changed so that you can really understand and learn sort of where the specific issues are and the specific regulatory changes. So today we're going to talk big picture, and then we'll have a whole series of webinars over the course of the summer on the more specific factors and changes that will be coming. So today we'll start with an overview of the key executive orders and actions that are directing the deregulation and talk about what those are, and then talk about how that actually happens. What will the agencies do to bring about the repeal of the different regulations that they might determine should be repealed? And what are the legal risks and potential challenges to that deregulatory approach? Megan's going to help us really talk about a couple of different routes that the administration can go through, and there are sort of pros and cons in each, and we'll help to see where the risks lie there. And then sort of other takeaways for the regulated business community and the organizations that represent them. Are there ways to be involved and ways that they can be engaged to help repeal the regulations that they don't like, or to fight a repeal of ones that they think are helpful and important for the industry? So we'll go through these four areas and hopefully be able to give you some good insight on what this might look like. Feel free to pose questions in the Q&A section. We will either try to address them kind of as they come in, depending on what they're related to, or we'll leave a little bit of time at the end to go over a full any other remaining questions. This session is offered for continuing legal education, CLE. We will be giving you a code kind of midway through, and at the end, you'll need that code in order to get the CLE for your state. So let's start with a quick overview of the executive orders. Sort of upon the assumption of the presidency, President Trump issued sort of two key executive orders. One was to rescind a number of Biden era executive orders. So this gets back to kind of the theory of the pendulum, where the presidency swings back and forth, and everyone's executive orders can be repealed and replaced, so to speak. And then also freezing any rulemakings that had not been completed at the outset. And Megan, that's a pretty common one to do, right? Is to sort of freeze any pending rulemakings that haven't finished up.
Yeah, no, that's standard fare, and it really is just putting a pause so that the agencies can go back and review what's in the pipeline and make a decision about those rules.
And then there's another executive order that imposed a fascinating 10-for-1 deregulation requirement. I don't know about you, Megan. I became a lawyer, so I didn't have to do math. But the idea for the 10-for-1 is that for every one new regulation, the agency has to roll back 10 different ones. And we'll talk about what that means a little bit more a little later on in the presentation. Then it starts to get a little bit interesting. The president issued an executive order saying that agencies should rescind all unlawful regulations. He then provided a memo on sort of what that meant in more detail, and then went further to talk about the sector-specific deregulatory overview. So, I'm just going to pop up some of these. The regulatory freeze and pending review, we went over in some of the initial rescissions of the Biden executive actions. Again, these were undoing about 78 different executive orders, but we're primarily focused on DEI, immigration and climate policy, kind of the things that we think of the Trump administration was focused on pretty extensively. And then there were some more rescissions after that. I think it's useful just to kind of think about this timeline. And I mentioned that we had done our series on sort of the first 100 days of the administration, but it really is still early in the administration. And as we'll talk a little bit about as we go through here, one of the things that's tricky with some of these deregulatory measures is that the administration still isn't staffed up. There's still a lot of Senate confirmed positions that haven't been filled yet. And so it may be hard to undo some of these regulations without having the staff in place to actually do them. So, Megan, we now come to the 10-for-1 deregulatory executive order, and it includes sort of the 10-for-1 total incremental cost of all new regulations has to be less than zero. And then it also changed some OMB rules and sort of the cost benefit analysis. And obviously the aim is to try and deregulate, simplify things. But I guess I'm curious your thoughts on sort of how 10-for-1 and sort of less than zero happens here and what that could possibly mean.
Yeah, I mean, I think it's a catchy way to instruct the agencies to assume a deregulatory posture. And so to the extent you have agency heads coming in and they have policy priorities and their regulations that, they're interested in promulgating, they have to first identify 10 regulations that they will rescind, and then they have to very carefully think about the incremental cost of any new regulation. And I think we'll get to this, there might be another slide later, but we've seen the agencies kind of tackling this executive order in various ways to figure out how to make the math work. I mean, I'm also not a math and science person, but I think the agencies have gotten the message that they have to do a lot of rescissions in order to put anything new out.
Great. Now I think the next realm are some really interesting and in my mind, but welcome your thoughts too, Megan, of sort of kind of unique and different approach to sort of how deregulation can work. So I'll turn that over to you maybe to chat a little bit about sort of this piece.
Sure. So we saw this executive order that kind of had the framework for deregulating on the theory that existing regulations, and this goes back not just Biden era regulations, but the whole rule book, I think, is really on the table for agencies to re-examine their rules and determine whether the rules, and we can get to it, get to the specific Supreme Court cases, but whether the rules are unconstitutional. They raise sort of what the EO calls constitutional difficulties. I think that is really at core, and we see this throughout the executive order. It's in some of the bullets here. Trying to cabin the agencies to their express statutory authority, sort of the mission of the agency that Congress envisioned and the explicit authority that Congress gave to each agency. And when the agencies are going back to do this review, if they identify regulations that go beyond the four corners of the statute, those are sort of red flags for, do we revisit this regulation? And if we do revisit it, how do we go about rescinding it?
One of the ones I'm curious about on this little list here is sort of harming the national interest. It seems sort of, in my mind, a bit of a head scratcher in the sense that if a rule was promulgated through notice and comment rulemaking, has been upheld by a court, is based somewhere on a statute, obviously that maybe is debatable in some cases. It's hard to argue that suddenly we have to rescind something unless maybe there's a change of circumstances.
Yeah, and I think this goes to the broader messaging about the concern with the amount of regulation, the concern about burdening economic growth, about burdening businesses. And so when we see harm to the national interest, I think it's like how do we promote growth? How do we rescind regulations that may be hampering economic expansion? And some of it really is a question of interpretation, right? So you could have a reasonable argument that a regulation is consistent with the statute, is actually promoting the agency's mission. Someone on the other side might say, no, that's not how I read this. That's not my sort of understanding of what the regulation is accomplishing. And something that's not on this slide, but is in the executive order, maybe goes to this a little bit too, which is about the enforcement discretion that the EOs give to each agency, which is to say, not only should you take another look at the rule book, think about what to rescind, but also if you have rules on the books that are not advancing the national interest as articulated in this executive order and the related documents, consider not enforcing that, or deprioritize your enforcement of that regulation. And so it really is trying to empower the agencies to do less enforcement for regulations that might be disfavored.
So I guess in that context, the hard part is again kind of going back to that the swing between administrations. If you don't repeal the regulation, you just don't enforce it, then and however many years later you can start enforcing it again.
Yeah, and some of what we'll see throughout the presentation today and with the follow-on webinars is one of the questions here is how quickly can we implement the policy goals? And so one way to do that quickly is to leave a regulation on the books and then exercise enforcement discretion and message the fact that the agency is not going to be enforcing that regulation. But Ron, it raises exactly the question that you flagged. If you're a regulated entity, the regulation is out there, you're legally obligated to comply with it. You're now in a period of, reduced enforcement, but it doesn't get you off the hook for potential violations or having a new administration come in and look back if you're still within the statute of limitations window and say, we have violations going back several years.
Yeah, thanks. So then we come to the presidential memo that sort of implements this further. Megan, do you want to walk us through part two?
Sure. So this presidential memo came really followed from the executive order we just talked about and identified specific Supreme Court cases. And the cases involve, the audience will be well familiar with Loper Bright, which overruled Chevron, West Virginia v. EPA, which announced the major questions doctrine. There were a number of Supreme Court cases related to cost benefit analysis, cases related to affirmative action, to the Jarkissi case on agency adjudications, the Clean Water Act case, free exercise clause. The memo lists these specific Supreme Court cases and then really instructs the agencies to take a hard look at their regulations, determine whether any of those regulations are unlawful in light of these Supreme Court decisions, and then really directs the agencies to think about using the good cause exception to notice and comment rulemaking to rescind those unlawful regulations without going through notice and comment process. There are lots of questions about this process, what's intended, what the agencies will actually do. We'll get to some of that in the presentation, but it is really a sea change in how the administration is thinking about rulemaking and what to do with existing rules and how to determine, whether to keep a rule on the books.
Megan, it occurred to me that in Loper Bright, one of the things the Supreme Court said was, if we've previously upheld a regulation under Chevron deference, that sort of stays in effect. It doesn't suddenly get changed. And yet this EO sort of says, well, never mind, we'll repeal that regulation anyway.
Yeah, I mean, there's a little daylight there, which is the EO says, agency, if you relied on Chevron to promulgate a rule because the statute was ambiguous, this was your best reading of what the statute means, and you went forth and did what you thought Congress had intended here, you should go back and undo that and do it in a process that is quick and efficient and doesn't involve public comment in advance. So I think, I imagine the administration will say technically we're complying with Loper Bright. We acknowledge the regulation is still on the books, but it shouldn't be for long. And maybe that's how they square that circle.
Gotcha. And then there were also a whole list of sort of sector-specific kind of the orders direct sort of energy production. It promotes domestic energy development, not green energy, but more of the traditional energy with greenhouse gas emissions in all these different areas. And I think this is actually a good slide to point out that we are doing this whole series of webinars because each of these specific repeals, this stage we're still in the executive orders directing the agencies to do things. The agencies are starting to move a little bit, maybe making some noise about what they might do, but it's really going to be at the agency level where we start to see the specific things happening, and so we want to make sure that as that starts to happen, we bring you up to date news on in each of the particular agencies, and so you can tune in over the course of the summer for the next part of seeing how this comes into play in different sectors, in different industries in particular. So now we'll talk about sort of some mechanisms for repeal and revision. And so we've talked about sort of the bases for what the administration has said should be repeal or revision, and now down into kind of the nuts and bolts of how. And so the first part is potentially a request for information. And Megan, I guess there have been some RFIs on the 10 for 1. Can you kind of walk us through a little bit about what we're seeing, how an RFI might work, and what we might start to see, and particularly where some of the attendees who might be interested in trying to figure out, hey, can we submit a comment? Can we propose a regulation that should fit in this category? What are some of the concrete things that can be done in this phase?
Right. All great questions, and we're seeing some different approaches from the different agencies. OMB did solicit ideas. I think that's on the slide here for deregulation very broadly across the federal government, just to give you a sense of the level of public interest in this endeavor. In the 30-day comment period, they received more than 76,000 comments, which really span the gamut of various agencies identifying potential areas or regulations for rescission. But we've also seen the Department of Health and Human Services and an FDA came out with requests for information, which acknowledge the executive orders, including those that we just talked about, and really solicit feedback from the public. And Secretary Kennedy has a video message that goes along with their request for information that says they are undertaking the biggest deregulatory effort in the agency's history and ask the public to identify specific regulations that the agency should consider rescinding. And then we've seen, I think in terms of making this math work, what we've seen from some of the agencies like Department of Energy, for example, are proposals to rescind rules where they very clearly, consistent with some guidance that came out of OMB, identify rules as meeting the deregulatory criteria in the executive order. In other words, those rules would count toward the 10 rules that they might need to bank in order to promulgate a new rule. And in terms of submitting comments, so the agencies are a little different in terms of how they accept comments from the public, but across the board, you should be able to find on the agency's website notices of these requests for information and links to where you can submit comments. You can also go to the Federal Register's website and find a list of all of the agency's actions and links for submitting to the comment files. So those the whole intent of that system is to make it easy for the public to figure out how to submit feedback. And so those are sort of prominently displayed both on the agency's websites and the Federal Register.
That's very helpful. Given where we are, I mentioned earlier that sort of staffing is an issue at the agencies. It's from what I've heard from some clients is that there just really aren't, if they wanted to even try to reach out to people like direct, sort of political appointees, there just aren't people in the agencies even to reach out to. Really, you do have to kind of go through the public comment process here, or the public process right now until a few more people get into place.
Yeah, I've been hearing the same. I think it's always valuable to submit your comment formally through the public comment process, including because under the APA, the agencies have to take into account in any rulemaking any significant comments that are formally submitted through that process. But you're absolutely right, Ron. In the ordinary course, you would also expect to be able to set up meetings with leadership in the agencies to talk about the policy direction and policy changes. I've heard the same thing in terms of staffing up the agencies, that they're still very much in the process of doing that. And I think that's compounded by the fact that, of course, we've had a number of federal employees who have left agencies, so they're sort of staffing they're short-staffed in some places on the staff side, and then also still staffing up in terms of political leadership.
Great. So then the next sort of formal process, if you will, in terms of if they decide there are particular regulations that they want to repeal under these executive orders, there's sort of a two-prong approach here. The first sort of more common prong would be notice and comment rulemaking. And in up until now, pretty much anytime a regulation is repealed, it goes through notice and comment rulemaking. Seems to be that it has been the approach for the past however many years since the APA, Administrative Procedure Act, has been in place. Is that a fair?
Yeah, I think the way to think about it, the way the Supreme Court has articulated this, is that if a rule has gone through notice and comment rulemaking in order to be issued by the agency in the first instance, if the agency wants to go back and either rescind the rule, amend the rule, it has to use the same procedures that it did, absent an exception. And we'll get to that, potentially big carve out, but absent an exception, the agency would need to go through notice and comment rulemaking in order to rescind a regulation.
And so as someone who has been at the helm of the legal department of an important agency, you know the ins and outs of rulemaking very well. You want to walk our audience through sort of what that typically means? I'm sure many of them have seen it at least in some form or fashion, but it'd be great to get a good sense of what's required and how it happens.
Sure. And I'll say the process by design is intended to really require the agencies to think hard about these rulemakings. It is, you often hear the complaint that major rulemakings take a lot of time, that it's a slow process. That is by design under the APA. And part of that is the way the process works under the statute is the agency puts out a notice of proposed rulemaking that walks through both the regulation, the proposed regulation itself, but also importantly, the agency's reasoning, the record that the agency has in terms of facts that it's gathered, its initial economic analysis, and all of that is in the notice of proposed rulemaking for the public to review, to internalize, and then ideally to provide comment on, for the agency to hear from the members of the public, regulated entities, those with an interest in the topic of the regulation, how the regulation will actually work in practice, what the interactions will be, if the agency has missed something, if there are, additional facts that the agency needs to take into account, costs that haven't been considered. So there's an opportunity, usually it's a minimum 30 days, often a 60-day comment period for the public to weigh in on what the agency is proposing. And then the agency really goes back, and there's a lot of work that's done internally at that point to digest all of that feedback that came in, to think about whether changes should be made to the proposed regulation. And expert staff at the agency at that point is working on finalizing a rule that would then go out into the public, taking into account everything that's come in, and be published as a final rule, usually with an effective date that's 60 days in the future. And that would then be the governing regulation.
And to your point about the agency taking into account comments and making changes to the rule to sort of potentially address some of those, there's even a world, I believe, where if they go too far and they change the regulation so much, then they have to sort of do a further round of comment because there's not necessarily appropriate notice as to what they're going to do.
That's right. So that's the logical outgrowth legal test, which is the agency has to provide notice, and you can change direction. And often what you'll see in a proposed rulemaking are questions of, should the agency do this, or alternatively, should the agency consider this other direction? That's to put the public on notice that there might be multiple paths the agency could take. But if the agency decides to go in an entirely different direction, that's not what the courts call a logical outgrowth from the original proposal, the agency then needs to provide a separate round for public comment on the new direction after explaining what that is. And so the agency can't sort of take in public comment and do a 180, head in a different direction, and finalize that rule.
And so this takes time, this process.
It does. It takes a lot of time. And again, as I said at the top, that's really by design, to make sure that we get the best possible rules out of the agency, that they've taken into account public feedback, and that the agency's had an opportunity to let the experts do their work.
One of, I think, the things that's interesting is that this notice and comment rulemaking was designed in, I think, the 1940s, give or take, when the Administrative Procedure Act was first put out, where you really literally would have had people getting hard copies of the Federal Register delivered. You would be sitting at typewriters writing your comments. But now we have online forms that people can flood the agencies with comment letters. It's a change in technology that maybe the process hasn't really found a good way to adapt to, that makes it so time consuming now.
Yeah, and I think the agencies are continually looking at that process and trying to figure out, like, are there ways to more efficiently process tens of thousands of comments that might be coming in. But you're absolutely right that it is a very different time now than it was in the 40s. The agencies are frequently receiving voluminous public comment, which can be very helpful, but also can really slow down the agency's ability to respond and to make changes.
And so with that thought of it can take too long, it can be cumbersome, there are some exceptions to when you can do this. And there are limited, I guess I would say, and the courts have, I think, probably limited them even a little bit more than some of the statutory language. But there's this some exceptions for good cause, and maybe you could walk us through kind of the typically when when an agency uses the good cause exception to go through a not go through notice and comment and either impose a new rule, mostly impose new rules in an interim and then get comment and go forward. We'll obviously talk here a little bit about the other way, but maybe you could walk us through the good cause.
Sure. And before we get to the good cause exception, just to flag, there are some other exceptions to notice and comment. So interpretive rules, which may lack the force of law, policy statements, which are agency statements about discretionary authority, procedural rules, internal agency functions. So just I say that only because not every rule has to go through the full notice and comment process that we were just talking about. But in terms of the good cause exception, which has gotten a lot of attention lately because it was a focus of the presidential memo on unlawful regulations and their rescission, the statute provides that an agency for good cause, which the APA defines as impracticable, unnecessary, or contrary to the public interest, an agency may issue a final rule without going through the public comment process. And Ron, as you alluded to, the courts have construed what constitutes good cause pretty narrowly. So, one example is in an emergency situation. This comes up, for example, if you have, if there are a public safety issue, like you have to prevent boats from traveling in certain navigable waters because of a security concern. You don't have time for public comment, that the Coast Guard needs to put that rule in place right away. The DC Circuit has said, on the other hand, if there's not and this has come up in, various EPA cases, if there's not a sufficient threat to the environment or to human health or some sort of emergency that the agency can't invoke the impracticable prong of the good cause exception. The second issue is like if it's just not necessary because the rule's entirely administrative or it's insignificant, inconsequential to the public and industry, you wouldn't expect to get any comment on it, even if you put it out for comment, or if the requirement is already in the statute. So OPM a number of years ago implemented the Social Security Number Fraud Prevention Act and promulgated rules that prohibited agencies from sending Social Security numbers in the mail, absent certain exceptions. That was a statutory requirement. The agency wasn't required to have public comment. And then this last piece, contrary to the public interest, that sounds like it could be broad. The courts have applied it fairly narrowly to situations where the interest of the public would be defeated by providing advance notice. For example, if a rule could cause some kind of financial manipulation of a market, which the statute is intended to protect, you might not want to have notice in that situation. An example is in the 1970s with the oil crisis, there were some regulations that were issued without notice and comment in order to avoid, raising prices or worsening supply issues. Or you have national security issues. For example, there have been instances where the FAA has suspended airmen because the pilot posed a security threat. And so that's a pretty narrow understanding. And it's flagged in the slide, and I think worth underscoring that it's possible, notwithstanding that the case law is very well settled in this area, that a court taking a de novo look at the statutory language might say that the interpretation should be broader.
Thank you. As we have gotten about the halfway marker a little bit more, I want to provide everybody with the CLE code So our code for today is Deregulation 2025, all one word, no space, Deregulation 2025. I'll provide that code again at the end, but that's so you can get your CLE credit for today's session. And then Megan, in terms of the statutory construct of good cause, the courts have so far to date taken a little bit of a narrower view, and so that'll be an interesting to see how that has played out. I think, correct me if I'm wrong on this, but I think it's mostly the DC Circuit that has sort of narrowed this as opposed to a Supreme Court case at this point in time.
Yeah, a lot of the law is the DC Circuit's case law, and it's been broadly accepted as the interpretation of this provision of the APA, but we'll certainly, I expect that we will see some challenges to this, and we could have a case that goes up to the Supreme Court and invites sort of a new look at the statutory language.
So if there's good cause, and we've got a couple of questions about our thoughts on this when it comes to repeal, maybe we'll get to that after we kind of cover this a little bit more. But so if there's good cause, then the agency can go to the interim final rule. Do you want to walk us through that a little bit more?
Sure. So an interim final rule, the courts have said the emphasis is really on final. So we talked before about how in the ordinary notice and comment rulemaking process, the agency would put out a proposed rule and then open that for comment, take account of the comment before finalizing. The interim final rule sort of flips that process. So the agency puts out a final rule. This could be a final rule rescinding a prior regulation. It could be a new rule. And it will invite comment, but the rule is final when it's published. It's not a proposal. And the agency may take account of comments, may make changes down the road, but this is we talked about the length of time that the rulemaking process could take. This is a much quicker process to a final rule, but you lose the public comment before you finalize.
And so if we were dealing with sort of the deregulatory framework, the concept here would be there's a rule on the books. We're repealing the rule, and please provide us your comments about the fact that we've repealed the rule.
Correct. Yeah.
And I'm intrigued, it's one thing, okay, we take the rule away, but now potentially there's sort of a hole there of other things that fit. And so you would have to potentially issue an interim final rule, sort of either filling that hole or fixing other problems that result if you go through this process, which starts to be an interesting sort of situation where now you're creating new rules under the interim final rule in a situation where you might not have had that same good cause. If you're starting from scratch, you wouldn't have the good cause, but you've created the reason because you're repealing under this executive order for one of the reasons.
Yeah, there's a lot baked in there, and I think all of it is right. But one thing to keep in mind, as I know many in the audience will know, is that agencies have interlocking rules. There's often a whole regulatory framework that's been built up over time. And so it really is a challenge if you're talking about going direct to final where you're rescinding a rule and you don't have public comments, you don't have an opportunity to have that back and forth to understand what the downstream implications of rescinding that rule might be. Or maybe you rescind and you have, a prior rule spring back, what that means given how industry might currently, have structured itself, or sort of programs that have been put in place to respond to the regulatory framework. And so it really is like, you're pulling pieces out without a full understanding necessarily of what the implications will be.
And then another thought, I guess, if an agency rescinded all the rules that it promulgated pursuant to a particular statute, you would then have the statute that's still there. The agency presumably has enforcement authority based just purely on the statute without the regulations, but you're left in a situation then where there may be a lot of uncertainty for the regulated industry in a situation like that.
Yes, I think that's right. And then layering on top of that, the fact that the agencies have been directed to exercise enforcement discretion. So you might imagine, some pressure from the White House justice sort of, we're not enforcing the statute, we've rescinded the regulations, but we end up in a situation where the law under the statute may still be on the books. You will have difficult questions, I think, about that situation, but also, it is very important to consider, and we'll probably get to this later, compliance and statute of limitations issues, and the fact that, making big changes now may not be advisable given all the uncertainty that we're talking about.
There's another approach to sort of getting rid of regulations, if you will. This requires a challenge to the rules. I think you have some experience defending agency rules in court when those challenges come. But this is almost the private sector using the courts to undo a regulation that's in place. What does this look like?
Yeah, so this is in terms of ease for the agencies, like the least amount of resources to be committed, and depending on the court, sort of speed, agencies can strategically use existing litigation. So, for example, a rule that was promulgated during the Biden administration that was challenged in court where that case is still pending, the agencies have some difficult choices to make. Like, do they continue to defend the rulemaking while sort of publicly signaling that the agency is no longer supportive of the rule, in the expectation that the court may agree and find that the rule is outside the agency's authority, in which case the court would do the work of vacating that rule, in other words, wiping that rule off the books, leaving the agency free to sort of wash its hands of the rule without having to grapple with any of the difficult notice and comment rulemaking, good cause exceptions. And we're seeing some of that play out. And I think it is appealing for agencies. It's also challenging because they have to make hard decisions about the position that they'll continue to take in litigation.
One of the things, this seems to me to be a way, if there were either an industry group or an ideologically oriented group that liked deregulation, that once the agencies start to come up with their list of sort of Loper Bright rules, in other words, rules that rely purely on Chevron deference in order to enact them, you could see private parties bringing lawsuits, and then potentially the administration just, yep, you're right.
So this brings up a case that we haven't talked about yet, but another administrative law case from recent years called Corner Post. So normally the APA has a statute of limitations that would make it harder to challenge. Maybe not rules that were promulgated during the Biden administration, but earlier rules. But now you can actually form an organization that is regulated by an agency rule, and under the Supreme Court's decision in Corner Post, that cause of action accrues when the organization is regulated for the first time, which may be when it is formed. And so you could bring a challenge even to long-standing agency rules now, and you could make exactly these arguments that when the rule was promulgated, it was done so under a Chevron framework of understanding that the agency had broad authority that's not consistent with how the courts now view it, or the cost-benefit analysis isn't up to sort of modern standards. Whatever the challenge might be, you could bring a facial challenge now even to much older regulations. So I do think that there are potential avenues there, and you're right, Ron, that puts the agencies in the spot of having to figure out, will they defend those longstanding rules Sometimes you'll have groups that intervene in defense of the rule if the agency's not willing to do that, or you might have the court appoint someone to defend the rule in the absence of an agency defense.
But the government could take the position that the plaintiff is right in a situation like that, and then it's up to other parties to bring the defense.
Yeah, it's fairly extraordinary for the government to do that, but it does happen, and I wouldn't be surprised if it started happening with some additional frequency.
I think it's going to be one of the interesting things to keep an eye out for, and potentially opportunities for people who are struggling with the regulation and it might have a better case now than they did in a prior sort of universe.
Absolutely right.
So let's talk about sort of the legal risks and challenges to the different approaches to rescinding rules. So if the administration goes forward with rescinding some of the different rules under the executive order, what are the what are the pros and cons? Why might they select one over the other, and what are the different risks? So for the rescission through notice and comment rulemaking, we will start with the pros. And it seems like there are, it allows for public comment and the policy adjustments like we've talked a little bit about. You would not have the sort of underlying procedural litigation. In other words, someone might bring the APA challenge to the rescinded rule, but they wouldn't be able to say, well, you didn't do it the right way, as long as if you went through the notice and comment rulemaking. And then it also seems like you've got the situation where it would be harder to kind of for that pendulum to swing back and forth. The agency would have to go through a new rulemaking record probably to justify bringing a rule back that had been rescinded through the notice and comment process. What are your thoughts on sort of if the administration were to go this route, do the public comment, and then talk a little bit, if you would, about they go through public comment. There's still a litigation challenge, but it's not quite the procedural litigation challenge.
Right. So I think what they do, if they go the public comment route, they have the benefit of public comment. I think for all the reasons we discussed, there's some advantages to the agency with that. But setting that aside, they do take some of the low-hanging fruit in terms of potential litigation challenges off the table. It takes more time to rescind a rule through notice and comment rulemaking. The trade-off, though, is that you may not end up in years of litigation, around whether the good cause exception applies, for example. So you may be able to actually get to an answer more quickly. And I think we'll see some agencies going the notice and comment route. We're already starting to see some of that, from EPA and other agencies that are either putting out proposed rules or indicating they'll be doing that. It does, and I know we're starting to get into the cons here, but it does take a long time, as we've talked about. What we're seeing in terms of the pressure on the agencies and the pace of the executive orders and all of the messaging is really a move quickly, undo the regulations, as expeditiously as possible. And we, through these executive orders and presidential memos, will provide you with the tools you need to do that and set you up for potential success in court. And so I think the trade-offs here are really like how time-consuming it is versus kind of getting toward the immediate accomplishment of policy goals more quickly. And we'll see. And I don't think we're going to see a uniform approach across the agencies. I think we'll see a variety of approaches, and that will tee up, potential challenges.
Yep. And then just kind of rounding out the cons of this approach, there's still the potential challenge for for something that's inconsistent with the statutory mandate. And then, as you say, it takes a lot of time and it may not accomplish the policy goals that they're after as quickly as the administration might like to do that. The other approach is, of course, the rescission through the interim final rule without the notice and comment rulemaking. And I'm actually going to pull up all the pros and cons here so we can kind of talk about them because I think they kind of interrelate a little bit. So obviously, it's kind of a speed versus certainty piece.
Yes, I think that's right. And on the certainty side, you have both the potential for an APA challenge in terms of whether the agency was authorized to forego notice and comment. And I think I would expect to see some losses there early on in the litigation. So the agencies would also have to be prepared to take some losses from, district courts who are bound by circuit precedent on the meaning of good cause, or it's a little bit of a heavy lift for an agency to do this and go in expecting some initial losses in court. On the other hand, you're sort of shifting the resources and time away from the rulemaking process to the litigation, but you get the rule out there much more quickly if you can do it without advance notice and comment. And so there's the litigation uncertainty, and then the other uncertainty dovetails with what we talked about earlier, which is you're flying a little bit blind as the agency if you're going into a final rulemaking on a significant rule or the rescission of a significant rule, and you haven't had an opportunity to really hear from the public about the proposal. And for all the reasons we talked about before, you may not fully understand all the implications or how the regulated entities will be affected by the absence of the rule.
And it strikes me that could be a situation where even a regulated entity that doesn't like the regulation may have been happier with something rather than nothing if there's not the opportunity to sort of build new around or make sure that it's clear how the lack of the regulation sort of fits into the whole scheme there.
Yeah. I mean, I think we're in a world right now where there are various paths that the agencies can take. They are very likely going to take various paths. Each path has its own set of challenges and potential pitfalls. And I think we'll certainly see challenges whichever route the agencies go. And I expect we will have a number of court decisions revisiting some of these basic APA principles that we've been talking about.
So that brings us to perfectly to the next question about who might challenge the rollbacks. And it seems like maybe I'll have you go through kind of the list and sort of there's a perception perhaps that there's sort of pro-regulation and anti-regulation forces in the world, but sometimes there's pro one kind of regulation and pro another kind of regulation that sort of might be battling each other in these situations. And so there could be really some interesting different sort of categories of litigants that might challenge a rulemaking reversal.
Yeah, and I think a good example of that, Ron, is in the Department of Energy has already proposed rolling back dozens of regulations, including regulations that target energy efficient standards for appliances. Some of those have been on the books for decades. And manufacturers have really invested a significant amount of time, energy, and talent in meeting some of those standards and also gaining business advantages from their compliance and being able to certify compliance. And so we've already seen some industry groups that have expressed support for the existing regulations that are being targeted by Department of Energy. Obviously, there are always hard questions when you're talking about a potential lawsuit and who might be willing to be a plaintiff or a petitioner in such a lawsuit. I think that's why, if you look down the list here, you often will see suits brought by public interest groups, by nonprofits, by trade associations, which have a little bit more of a distance from the agency because they're not directly regulated, and maybe they're members who are regulated, and the trade association may be getting a lot of pressure from members to try to push back against deregulation in some of these spaces where you've had entire industries grow up around existing regulations. And then, of course, we've seen state governments weigh in on both sides. The SEC's climate disclosure rule is actually an excellent example of that, where we had Republican-led states who sued the SEC to challenge the climate disclosure rules, and then a group of Democratic-led states who intervened in defense of the rule. I think you could end up seeing more of that, especially, as we were talking earlier, if we end up in situations where either the agencies are making decisions not to defend, or there are questions about how forceful the defense will be. And we may see groups that intervene in those cases in order to provide a defense. And I know we're coming up on time here, but we're almost at the end, so.
Yes. So, what to expect here. Obviously, there's going to be a continued focus on deregulation. I think it's pretty clear that while the administration has a number of balls in the air that it's juggling, this deregulation framework is important and high on their list of things to accomplish. And it also seems that it's an area where the agencies can do something, where a lot of what we've seen in the first kind of 100 days has been very White House focused in terms of different initiatives. This is one where once it's kind of set in motion, it can kind of keep churning away in the background at the agency level. We'll then, I guess, Megan, be on the lookout for kind of the agency announcements, right? That's kind of the next step, is what we would expect, is either a list of regulations that they're potentially targeting, or a list of regulations, or even direct interim to final, or like an interim to final notice potentially could come out on some of these.
Yeah, that's exactly right. And we're starting to see some of that already from the various agencies. I know that we also have to share the CLE code again. So want to make sure to do that before the top of the hour. And that's Deregulation 2025. So everyone has the code. I think we will all be watching closely as the agencies continue to roll out their various policy agendas in this deregulatory environment. And we'll have, I know a number of the questions we've gotten are specific to different agencies or different sectors, and we'll have a number of webinars coming up over the course of the summer that will answer many of those specific questions that you all have posed to us that we weren't able to answer today.
So if tomorrow an interim to final rule repealing a regulation were issued, what's sort of the fastest timeline you can see, Megan, that it could get up to the Supreme Court, if presumably that's where that sort of good cause litigation would have to wind up?
Yeah, I mean, depending on how high profile the rule is, you could see lawsuits. I mean, we had a petition for review filed the very same day that some of our rulemakings come out. It can take some time to wend its way through the courts of appeals. Some of it will depend on whether the effect of the rule is stayed pending the litigation. And what that does is either tee up a potential for kind of seeking emergency relief in the courts of appeals. It could potentially go up on, what's called a shadow docket to the Supreme Court versus having the agency issue the rule but stay its effect and having the litigation play out, in which case it would likely, I wouldn't think we would see it go up this term, but maybe next term to the Supreme Court. But it depends a lot on the choices the agency makes at the outset in terms of whether we've teed up an emergency docket situation or not.
Great, thank you. Well, that brings us to the end of our presentation today. Again, the code was Deregulation 2025 for your CLE credit. Megan, thank you so much for joining me. This was hopefully helpful to all of our participants today, and to them to be on the lookout for our sector-specific programs that'll be announced in short order to come over the June and July period, so that we can talk about some of the specifics. And I think we did see a number of questions about some of the particular topics, agencies that really will take time to develop the answers to some of those, because they are very agency specific, and we'll have to kind of see where things go. So thanks everybody for joining us today. We look forward to having you on future sessions.